Hello, everybody, and welcome to ENS Africa's CPD series. My name is Jessica Blumenthal, for those who don't know me, and I'm a director in the Banking and Finance Department. This is the second in our ESG masterclass rendition of the CPD series. We kicked off yesterday, and we will be running our series throughout the month of April and May. The great thing about the series is that each of the webinars or masterclasses has been accredited for CPD. So attendees are able to earn a CPD certificate for the hour attending this masterclass. But please remember that for CPD purposes, we need to make sure that we can verify that you have been in attendance. And so if you are needing a CPD certificate at the end of this presentation, please do ensure that you've stayed on for the entire time. We can't issue certificates to those who've only been on for a portion of the session, so please do just bear that in mind. Perhaps some other housekeeping rules before I say a little bit more about the series and then pass over to my panelists who are waiting to drive forward a very exciting discussion on crypto. You are able to ask questions during the session. You will have had an opportunity when you first received the invite to send in some questions, and thank you to those who did have taken those into account. But if a question comes to you while you're listening to our panelists and the debate that they're having, then please do use the Q&A function at the bottom of your screen. Please don't use the chat function because it's difficult for us to monitor the chat function, number one, and number two, we actually can't answer your questions in the chat function. So please do use the Q&A or the conversation button, as it's otherwise called. If you load your questions in there, then our moderator, Alex Taylor, will be able to pick them up and pose them to the panelists once they're finished answering another question. So just please do remember that. And then finally, just a reminder that this is the one part of a many-parted series. So there are upcoming events and masterclasses being presented. At the end of this webinar, you'll see the list of those which are upcoming. You can register to attend any of them that you'd like to do so. We've tried to use this CPD series this year, as we did last year, to showcase some of our experts' thought leadership on some topics that are pertinent or at least fit under the ESG umbrella. Last year, when we first started using the CPD series for that purpose, a lot of our sessions were quite introductory, helping our financial services sector clients and also anyone else who's been able to attend our sessions to really get to grips with some of the emerging trends and themes under the ESG umbrella. But the masterclasses that we're offering this year go one step further, and we've used the opportunity to pull together multi-jurisdictional and multidisciplinary teams from our firm and to really discuss topics that we think are very hot in the market at the moment and will be of relevance and importance to you, and to try and draw from those topics either a governance thought or something that fits under the E or something that fits under the S. So there's quite a wide range of topics that you can look into as part of the series. Obviously, today we're going to talk about crypto and some of the regulation to watch and emerging trends in that space. And we're very lucky to have our experts populating our panel today. So without taking up any more of their time, as I'm sure they're going to need all of it to get through their discussion, I'm going to hand over to my partner, Alex Taylor, who is also a director in the Banking and Finance Department. And Alex is going to moderate our panel today. So thank you, Alex. Over to you.
Thanks, Jess. Hoping everyone can hear me. So thanks so much for the introduction and welcome to all our guests watching our discussion today. It gives me great pleasure to introduce our three panelists for today's discussion. Our first panelist is Professor Angela Itzikowicz. Angela is a renowned authority on financial services and banking regulation in South Africa and is also a partner in our Banking and Finance Department. Angela will be setting the scene for us on where we are with the regulation of crypto assets in South Africa currently, and will be taking us through some of the latest regulatory changes in this regard. Our second panelist will be Chavi Gompo. Chavi is an associate in our Mauritian office, specializing in banking and finance law as well. Chavi will be giving us some insights from a Mauritian perspective. In the Mauritian market, virtual assets, which include cryptocurrency, have recently become formally regulated. So she'll be teaching us a little bit more about that. Our third panelist for today is Ira Gunning. Ira is a partner in our banking and finance practice in Johannesburg as well. And one of Ira's fields of deep specialization is anti-money laundering regulation and compliance. So Ira will be unpacking the implications of the recent inclusion of crypto asset service providers as accountable institutions under the FIC Act. And as Jessica noted, if you have any questions for our panelists while we're going through the discussion, please pop these in the Q&A. And then depending on how we're looking for time, we'll either pose them to the panelists during the discussion, or we'll direct your queries after the session and get back to you. So without further ado, let's call on our first panelist, Angela. Angela, what can you tell us about where we are on the regulation of crypto assets in South Africa, and what are the latest regulatory movements in this regard?
Thank you. Thank you very much, Alex, Jess, and to the audience for attending these very well thought through series. So when thinking about what to say, I was thinking about a talk that I gave at a conference a few years back in Singapore. And the title of my conference, of my talk, was Regulating Crypto Assets, Oxymoron or Necessity. Now, while the question for me at least still remains a very valid one, I think it's moot in as much as most jurisdictions across the world have decided that regulation is a necessity, and many countries, if not all, either by outlawing it or by permitting it, do now regulate crypto assets. I wanted to say at the beginning, please, for the lawyers amongst us, I'm going to rely on the legal doctrine that our courts give effect to substance and not to form. So please forgive me for not putting up any slides or using a PowerPoint. Back to the topic there. I thought it would be quite useful just to give you a landscape or give you an overview of the genesis of the regulation, the steps that were taken, where we are at, and where we still have to go. So I think the genesis is certainly, or was certainly, the coming together or the forming of the Intergovernmental FinTech Working Group. Now, that working group was formulated in 2016 and consisted of the Financial Sector Conduct Authority, the Prudential Authority, Treasury, and FIC. The purpose or the remit of that group was to consider the policy around regulating crypto assets and also the approach that should be adopted to the regulation of crypto assets. Some 2 years later, in 2018, a second group was put together. This was called the CAR Working Group, which, as its name suggests, focused mainly on the regulation of crypto assets, as distinct from the broader FinTech, which was the remit of the Intergovernmental FinTech Working Group. Added to the members, or the parties, if you will, of the CAR Working Group were SARS, as well as the FIC. So those were the two working groups that were tasked with looking at policy as well as regulation. What both of those groups, or the approach that both of those groups adopted in the regulation, was a stance that most jurisdictions have adopted worldwide. And that is, while the technology may be new, regulation, or the best way of regulating, is to adopt a functional approach. So rather than looking at the technology, the laptops, API, or rather the internet, telephones, let's look at the function that these services are providing. So that then was the genesis of the regulation. And much has been written about this. One of the most interesting articles, or certainly the most interesting topics, was that of, is it just a case of old wine in new bottles? And I think very much or to a large extent it is. So there you have your two working groups looking at the policy around regulation and also making some suggestions as to how to regulate. The thesis being that it should be technologically neutral and that regulation should adopt a functional approach. In the policy paper issued by I forget which of the two working groups, probably the CAR working group, a definition of crypto assets was suggested. Now, don't worry about the definition. We can certainly let you have that definition in a slide or in some kind of form after the discussion. But pretty much that definition put forward by the CAR working group is this. A crypto asset is a digital representation of value that is not issued by a central bank, but is traded, transferred, and stored electronically by a natural or legal person for the purpose of payment and other forms of utility. Now, that would have been an extremely wide definition of a crypto asset and would have caught a number of activities, but it's shortened in the sense of the definition requiring the application of cryptography and that the underlying that the technology should be run along a digital ledger technology. So that, I think, narrows the definition somewhat, although it's still a very broad definition. It's also broad enough to cover all of the use cases of crypto assets. Primary use cases, at least for the moment, are for investment purposes and increasingly for payment purposes. So that's the definition that was put out by the CAR working group and, as you'll see, has been adopted or implemented in the regulation that followed the policy discussions and the policy documents. What the position paper also stated was that the focus should be on three main areas. The first is to regulate anti-money laundering and terrorist financing, or the counter financing of terrorism, to have a regulatory framework around that. Secondly, to have a licensing and supervising regime from a conduct of business perspective. And the third was a regulatory regime for cross-border flows. So those were the three areas that the policy paper suggested our government focus on as the first steps in regulating crypto assets. So the first step was, as happens to be the first as set out in the policy document, that all crypto asset service providers, and that term is defined in the Financial Intelligence Center Act, all of those should be included as accountable institutions in terms of FICA. Now, my partner, Era, is going to speak to that in a lot more detail as to exactly what that entails for crypto asset services providers. But Era, if I may, just into your territory and steal a small piece of your thunder, what we've come across very often is that crypto asset service providers say, thank you, we sorted. We are registered as accountable institutions. We do customer due diligence. Well, as Era is going to demonstrate, that's by no means enough to meet the requirements of the amendments to FICA and the amendments effected by the General Laws Amendment Act. But I'll leave that for Era. The second point the working group made is the regulation of crypto assets, or the licensing of crypto assets from a conduct of business point of view. And this was done in terms of FASE, or the Financial Advisory and Intermediary Services Act. On the 19th of October, the FASE, FSCA issued a document saying that phase was to be amended as of that date, 19 October, by the inclusion of crypto assets as a financial product. Now, we actually gave an opinion to the relevant regulatory authorities as to whether this could or couldn't be done. And we were actually of the view that we thought there would be difficulties in simply including crypto assets as a financial product under the catch-all provision of a financial product. But perhaps correctly with hindsight, the FSCA or the government decided not to take that advice, and they have included it as a financial product. Our thinking was, while it may be a good thing to regulate crypto assets, we weren't sure that the modus or the method in which they did it was the correct one. In that, in order to have done so, they would have to have demonstrated that a crypto asset is a product similar to the rest of the financial products. Now, a stark difference between all of the financial products and a crypto asset is that it is decentralized. There is no centralized authority. It's completely decentralized, whereas each and every one of the other crypto financial products does have some central issuer or some central authority. Excuse me. Anyway, to the FSCA's credit, that was a document, or the amendment was put out for comment. There were a lot of comments received, but curiously, no one, or at least none of my clients, sought to challenge it. And I think that that was the correct approach. One doesn't want to challenge something and enter into a fray with the only victory being a Pyrrhic one, where it wasn't worth their fighting the Financial Sector Conduct Authority in the long run. So what does that declaration say? Well, it sets out a definition, or it includes a definition of a crypto asset, and that definition is the same definition that I've just read to you, that it is runs along distributed ledger technology, that it involves cryptography, and that it is decentralized. So that's the definition that phase has adopted, mirroring that set out in the policy papers. So subsequent to the issuing of this notice, it issued a policy document giving its reasons for having declared crypto assets as a financial product. And again, I suppose they had no option, but again, so as to provide for a seamless transition, the Financial Sector Conduct Authority, the FSCA, has given those who play in the phase space in respect of crypto assets, they've given them until the 1st of June to register, or more correctly, they have between 1 June 2023 and November 2023 to register as a crypto asset service provider. So should you be worried? Are you affected by this? What do we mean by a conduct standard? Now, conduct standards certainly can mean different things as that term is used in different statutes. But in this context, if you are already trading in crypto assets, the Lunas, the Valas, the Yellow Cards, the Revex, and the banks who provide safe custody, you can continue doing that, but you only have until the beginning of May, or between May and November, to get your house in a row. What activities would you have to be conducting? Well, in addition to your having a financial product in the form of a crypto asset in your stable, you only have to be registered going forward if you provide advice and or render intermediary services. And only yesterday I heard somebody say, well, we don't do advice because it's robo-advice. Well, just as an aside, robo-advice is something which the Financial Sector Conduct Authority regards as constituting advice for purposes of phase. But that's detail. So, excuse me. In addition to the declaration and the policy document, which I've touched on very, very briefly, a general exemption was granted. And importantly, I think the Financial Sector Conduct Authority recognized that it would be ridiculous to regulate every crypto that has the qualities enshrined in that definition. You would find yourself having to register games, all non-fungible tokens, all tokenized assets, regardless of the underlying asset, would have to be would be recognized as crypto assets. So they have exempted in the general exemption mining and also non-fungible tokens. What worries me is that it's very easy for both utility coins and security coins to be regulated by the legislation. And to my mind, it would be ridiculous to regulate a coin which has no financial purpose, well, I suppose an indirect financial purpose, but all it really does is to give you utility in exchange for some kind of capital raise. But that's my view. I just want to make one point here, and I did look at the list of attendees, and I don't know how germane or relevant this comment would be, but I want to put it out there nonetheless. And that is, if you are trading in derivatives currently, and you want to link your crypto asset to a derivative going forward, the Financial Sector Conduct Authority takes the view that given that the underlying is a derivative, you ought already to have been registered, and you can't rely on the exemption simply because it's overlaid by a derivative or by a crypto or underpinned by a derivative. Okay, then there's also been, and I'll just touch on this very briefly, I'm conscious of time, and that is, there's also been, a paper has been put out calling for comments on specific exemptions. That was issued in December 2022, and a lot of those comments go to qualification requirements and experience requirements. And it has to, because how would you meet the qualification requirements or the experience requirements, given the novelty, not how much of a novelty it is, but given that it's going to be something regulated and people don't necessarily, or certainly wouldn't have for the most academic qualifications in crypto and blockchain and the like. So there is some forgiveness around there. It's not an absolute forgiveness. You will be exempted from the qualification exams, but you have to, so there's a rider to each of those exemptions. So, and we don't know how those exemptions are going to pan out. So that then is the second area, if you like, of regulation, conduct regulation as far as advice and intermediary services are concerned. This will probably be superseded in the longer term, where crypto assets will be recognized or regulated by COFI, the Conduct of Financial Institutions Bill, rather than in phase itself. I want to move very quickly onto the third of the areas identified by the policy groups and set out in the policy paper. And this is one which maybe it's better that I don't have a huge amount of time to talk to this, because it's one which makes me incredibly angry and which really gets me hot under the collar. And I was speaking about it at the Africa Bitcoin conference, and I was thinking to myself, maybe I've been a bit too outspoken and maybe I should have moderated my response somewhat. My response is going to be the same. Or rather my sentiments are going to be those that I articulated at the conference without moderation. So yes, I understand, of course I do, anti-money laundering legislation and that cryptos must be regulated, particularly given the grey listing. Although this, bringing them within the FICA long antedates the grey listing. Secondly, I understand the imperative of consumer protection, and that's why they must be regulated in terms of phase, these players. But we hear all the time how important payments are. It's all about payments. I think the most important thing in the whole fintech space today is payments. We hear how wonderful cryptos are in the sense of it in conducing to financial inclusion, how it will allow people to remit money at a fraction of the cost and within a fraction of the time that it currently does using one of the existing remittances, or remitters rather. But the Financial Surveillance Department has still not made up its mind as to whether crypto assets constitute capital for the purposes of the exchange control regime. And if it does, then the exchange control regulations would apply fully to crypto assets. Now that's fine. You know, if that's the view of the government or of the FinServ, that's perfect. But then don't be schizophrenic, if you will, in your approach to the regulation. If you have a look at the policy document, it says the definition of capital must be amended to include crypto assets. Not long after that, in its question and answer paper, the FinServ, I'm not sure who the author was of the document, but that the author says, yes, crypto assets do constitute capital, and you cannot, without exchange control permission, remit crypto assets. So I don't know where this leaves us. I do know that some people are turning a blind eye to it, others are adopting a more cautious approach. But I do think, whatever the outcome, the SARB FinServ has to nail its colors to the mast as to how they are going to treat cryptos for purposes of capital, and whether it is in fact an export of capital, given the technology involved and given the anonymity which inheres in cryptos. So yeah, we have to wait and see. The thinking is that what they will do is that they will make people who want to remit cryptos, they will create a new category of Adler license. They'll require them to be authorized dealers with limited authority, but none of the existing categories fit. So I think if I can give you probably the most important takeaway of the day is crypto assets regulated by anti-money laundering legislation to be regulated from 20 June 2023, sorry. And you really should start to get your matters and your applications aligned and prepared. Thirdly, we don't know what's going to happen with crypto and capital. But that's not the end of the inquiry. And I want to leave you with this thought. Given that the regulators adopt a functional approach, whatever you want to do in the space, you must check what you want to do against existing regulation. Consider the Banks Act. Could what you want to do be a deposit? If you want to issue an a coin rather than doing an IPO, does that coin constitute a security? In which case you must consider Financial Markets Act. Is it an offer to the public? Then there's the Companies Act. If you want to make payments, what does the National Payments System Act say? Would you be a system operator or a TPP? Or neither, if you simply want to do remit money or transfer value. So please be alive to what is there, but also be alive as to what is already there, and what you must measure your offering against. Thank you very much, Alex. I didn't look at my time. I hope I haven't gone too far over.
No
Thank
problem.
you very much.
Thanks so much, Angela, for those insights. That was great. There's certainly a lot happening in the space at the moment. So now, moving from our jurisdiction, which is perhaps at the start of its regulatory journey when it comes to cryptocurrency, to another jurisdiction, which is further along this road, I'm going to call on our second panelist, Chavi. So Chavi, to start, can you speak to us about a little bit about why Mauritius is such an attractive jurisdiction for setting up businesses related to virtual assets?
Thank you very much, Alex. Hi, everyone. I'm Chavi from the ENS Mauritius office. Today, let's explore a little bit of the crypto landscape from the Mauritius law perspective. So why Mauritius is an attractive jurisdiction for setting up business relating to virtual assets. As you're all aware of, over the past few years, virtual assets have grown exponentially. And this upward trend of virtual assets adoption has led to numerous business growth opportunities. And Mauritius has been keen to harness the benefits of virtual asset business. Why? Because Mauritius wants to become that fintech hub for Africa. So in this context, a range of new initiatives to propel this very fintech sector were announced in our national budget 2021 and 2022. Now, what's this fintech hub? It's called the Mauritius Africa Fintech Hub, the MAFH. It's a fast-growing ecosystem where a lot of stakeholders, including entrepreneurs, corporations, governments, tech experts, investors, financial service providers, where they come together to collaborate to build cutting-edge solutions for the emerging African market. Hence, I would say that MAFH essentially paves the way for international fintech companies to access our African market. So in order to better welcome these stakeholders, a new regulatory framework had become necessary, not only to tap and benefit from future growth, but also to protect the rights and interests of citizens dealing with virtual assets and virtual tokens. So Mauritius has also upgraded its AML-CAFT framework to be in line with revised international standards to curb the famous risk of money laundering. Following the revisions made by the Financial Action Task Force, we all know the FATF, in October 2019, regarding the methodology for assessing technical compliance, Recommendation 15 and Immediate Outcomes 1 to 4 and 6 to 11 were revised to reflect amendments in respect of the FATF standards, which incorporate virtual assets service providers. Hence, our regulation is a direct response to this Recommendation 15 of the FATF. So our famous law, Virtual Asset and Initial Token Offering Services Act 2021, known as the VITAS, was proclaimed on 7th of February 2022. Now, the very object of this act is to provide a comprehensive legislating framework to regulate business activities of virtual assets. VITAS addresses several fundamental aspects such as governance structures, risk management, disclosure of information, protection of clients, and so on. In addition to that, and very importantly, VITAS also provides for licenses dealing with virtual assets, on which I will touch upon in a while. Prior to VITAS, I'd like to highlight that any business activity wishing to undertake virtual assets involving cryptocurrency would only have had recourse to the following licenses. A, being the regulatory sandbox license. Essentially, it's a license which is applicable to business activities for which there is no or inadequate legal framework, or the digital asset marketplace license, or the custodian services digital asset license. But with the coming into operation of VITAS, both the digital asset marketplace license and the custodian services license cease to exist. Today, I would like to walk you through the core elements of VITES, elements which are going to be tested in the next few years in our jurisdiction. This will hopefully give an insight to the South African service providers as to what they may expect in terms of the underway South African legislative framework. So how did Mauritius go one step above with VITES? It's important to highlight that VITES empowers the Financial Services Commission, also known as the FSC, to regulate virtual asset service providers within the non-bank financial services sector in Mauritius. So the FSC has the power to license virtual asset service providers, to register issuers of initial token offerings, to monitor and oversee business activities of virtual asset service providers. There is therefore a set regulatory body responsible to regulate the virtual asset framework. Well, this helps promoting transparency in the sense that the FSC has the obligation to publish on its website a register of virtual asset licensees, which basically contains information on the names and address of licensees, as well as the issuance dates of their licenses. In addition to that, I'd like to mention that VITES provides legal certainty concerning different types of business activities involving virtual assets. How? There is a clear set of class of licenses established which applies to specific business activities. So for example, if you are a potential service provider and your business activity involves exchange between virtual assets and fiat currencies, or exchange between one or more form of virtual assets, then the virtual asset broker-dealer license would be applicable to that service provider. The second category of license would be the virtual asset wallet services license. Now, this involves business activity regarding the transfer of virtual assets. What's interesting with VITES is that VITES has clarified certain gaps and reduced ambiguity by introducing clear-cut definitions. So for instance, for this type of business activity, which I've just mentioned, being the transfer of virtual assets, it's defined as any transaction carried out on behalf of another person that moves a virtual asset from one virtual asset address or from one virtual asset account to another. Now, if you're a service provider involved in the safekeeping of virtual asset or administration of virtual asset, then a virtual asset custodian license would be applicable to you. The fourth type of business activity would be if you're a service provider and you want to participate and provide financial services related to an issuer's offer or sale of virtual asset, then the license applicable would be the virtual asset advisory license. The fifth and the last category of license under our VITES is the virtual asset marketplace license. Now, this license would be applicable to service providers involved in business activities related to virtual asset exchange. Virtual asset exchange, it's basically a virtual platform, whether in Mauritius or abroad, which facilitates the exchange of virtual asset for fiat currency or other virtual assets on behalf of third parties for a fee, and controls virtual assets on behalf of clients to facilitate an exchange. Now, to ease this licensing process, the FSC has provided distinct licensing criteria for each class of license. So for example, service providers must provide detailed business plan to the FSC, KYC documentations on shareholders, UBOs, directors. They need to provide information on internal controls and risk management, IT infrastructure, and so on. In addition, I'd like to mention that there is a prescribed processing fee and prescribed annual fee applicable to each category of license. So for example, for a virtual license custodian, the processing fee would be USD 1,500, an annual fee of USD 2,500. But for a license category virtual asset marketplace, the processing fee is different. It's USD 3,000 and annual fee 5,000. So the processing fee and the annual fee would vary from license to license. Because this fintech landscape is relatively new to market players, Vitus, and thankfully does so, provides further guidance on the technical aspects. So for instance, Vitus guides us as to what is a virtual asset service provider. So a virtual asset service provider, it's a business that conducts one or more of the following activities: exchanges between virtual assets and fiat currencies, or exchange between one or more form of virtual assets, or transfer virtual asset, or safekeep or administer virtual asset, or participate in financial services related to an issuer's offer or sale of virtual asset. So this helps informing service providers as to whether or not they fall within the ambit of the Act, and they're able to identify which clause of license would apply to them. Now, some more elements on Vitus. It's important to note that only a company and not an individual may undertake business activities of a virtual asset service provider. The applicant needs to have a physical office in Mauritius. The business activities needs to be directed and managed from Mauritius. Importantly, the company needs to maintain a minimum unimpaired capital and liquidity resource. The service provider is required to file audited financial statements with the FSC every year. Another important requirement under Vitus is that the applicant must satisfy what we call the fit and proper person requirement. So when the FSC is considering whether a person is fit and proper, it may have regard to the financial standing, relevant education, qualifications and experience, ability to discharge the relevant functions properly, any criminal record, and so on. So about outlining the specific requirements of the service provider, Vitus gives sufficient awareness and guidance to service providers as to what their requirements would consist of. Now, let me talk a little bit about risk. Against the backdrop of money laundering risk in the virtual asset sector, the FSC advocates very much of a risk-based approach when establishing business relationships with service providers. So geared towards consumer protection, legal players in Mauritius seek to protect and help to track those who are infringing the law. Through FSC rules, an additional layer of framework is also ensured that consumers are safe. So for instance, in February 2022, the FSC has issued what we call the AML CFT guidance notes for virtual asset service providers. These guidance notes depict salient money laundering and terrorism financing red flag indicators which are associated with virtual assets. Some of the red flag indicators would include scenarios related to anonymity, multiple high-end transactions made within a short period, geographical risk, and so on. Hence, service providers are required to identify and take effective actions to mitigate their money laundering risk. In addition to these guidance notes, Vitus imposes mandatory obligations such as disclosure requirements and cybersecurity rules requirements. So for instance, let me talk a little bit about the cybersecurity rules 2022. When dealing with software and systems provided by third parties, service providers must consider the impact of any outsourcing arrangements, They must identify any dependencies of business and need to protect clients against cybersecurity and operational risk. And the second rule that I would want to talk about today is the Client Disclosure Rules 2022. Basically, these rules set out that a service provider needs to communicate information to clients in a manner which is clear, fair, and not misleading, and needs to provide a description of the products and services and any specific technological requirements. So today, to end, I'd like to say that the Vitus is indeed an early harvest. Like any piece of legislation, there is always room for increasing future learning, sophistication, and institutional building in regulation. Indeed, the market is waiting to see how Vitus and the rules will be implemented by the FSC in practice. Thank you, Alex. I now pass over to Ira.
Thanks, Amal, Chavi. So, Ira, can you tell us a bit more about the implications of crypto asset service providers now being included as accountable institutions under the FIC Act? Oh, there we go. I see you've got your slides going. Over to you.
I was just battling to unmute myself. There we go. And Angela and Chavi, I absolutely loved your talks, and it's so interesting to see that you are actually quite light years ahead of us, Chavi. And of course, you had the Financial Action Task Force grey listing, where we are sitting now, and you managed to get yourself off the grey list, which is absolutely wonderful for Mauritius. And Angela, you were speaking about financial inclusion, the ease of using cryptos. But of course, along with that comes the risk of money laundering. And I'd like to start off with the Law 101, namely, what is money laundering? It's a term that we always refer to, but I find that very often our clients don't actually know what it means. In simple language, it means hiding the origins of your dirty money. So you're a cyber attacker, you carried out a ransomware attack, and you wanted to be paid in Bitcoin. Now you've got all the Bitcoin and you want to hide where this Bitcoin is coming from. That is typical money laundering. Terrorist financing, also covered in terms of the relevant legislation, that is preventing the likes of 9/11. I think that's easier to understand. And of course, a new thing added in December with the AML Amendment Act was the reference to proliferation of weapons of mass destruction and the prevention thereof. And that is basically spreading nukes, financing and spreading nukes. Now, of course, these are all terrible things, and we want to avoid it. And for that reason, we've got legislation such as the Financial Intelligence Center Act in place, FICA. But as we know, FICA and other pieces of legislation were amended in December last year. And why did this happen? It happened because of our Financial Action Task Force mutual evaluation, the inspection that occurred in 2019 and the report that was issued in 2021. Now, if you don't know what the FATF is, it is the International Anti-Money Laundering Watchdog. It cannot make rules that apply in a country, but it can make recommendations to its members to write their rules, their recommendations into our local laws such as FICA. And if we don't do it adequately, then of course they graylist us or blacklist us. And as we know, that happened to South Africa and on the 24th of February this year. So when they came to mark us, inspect us, and they issued a report, they found that we failed. They found us non-compliant as far as technical or academic compliance is concerned on at least half of the 40 ratings that they marked us on. So they said to us, get your house in order before February this year, otherwise we are going to graylist you. We made a lot of amendments to our legislation, partially to address, of course, the technical, the academic non-compliance, but of course we've also got issues that we don't enforce the legislation. But that's an issue for another day. So we made all these amendments, and then of course we were still greylisted because it wasn't adequate, and we find ourselves in the company of the likes of Nigeria and Cambodia and Syria now. So hopefully we can follow what has been done in Mauritius and we can get ourselves off that grey list as soon as possible. So the unsuccessful changes we made to try and avoid a grey listing including, and that is very important for today's session, amending the schedules to FICA. And specifically what I want to talk to today is the amendments of Schedule 1 to FICA. Now, Schedule 1 to FICA sets out who must FICA a client, who must KYC a client, who must perform CDD on a client. And of course, before the amendments, we had the likes of banks and lawyers sitting on that list. Then the amendments came about, and it also added certain crypto asset service providers. And before that, we already had financial services providers. Angela spoke to FAIS, but of course, crypto asset service providers don't have to be registered in terms of FAIS yet. The registration kicks in soon, but crypto asset service providers sit on a separate category of financial services, of accountable institutions in terms of FICA. Now, interestingly enough, if you trigger more than one category, for example, you are a financial services provider and you are a crypto asset service provider, you would have to register under both hats, so to speak. So you would have to register for different categories. There are, of course, others that were added to the list, such as credit providers and dealers in high value goods above 100,000 Rand per item. So what does it mean? What does it mean that you are now an accountable institution? First of all, you need to appoint a compliance officer. That is the first thing you need to do, because to register with a FIC online, which is a free online registration through the GoML system, which you have to do yourself, a lawyer or service provider cannot do that for you. You need a compliance officer's details, and your compliance officer needs to do this registration. So first of all, appoint a compliance officer and then register as an accountable institution with a FIC. Now, recently, the FIC issued a notice saying that the time period, 90 days from publication of these amendments have lapsed. They are aware of the fact that many new accountable institutions have not registered. Do it ASAP because you are on the FIC's radar. You have to develop and implement a risk management and compliance program. Now, this is a fancy name for an AML policy based on risk. The risk-based approach is so absolutely crucial in terms of FICA, and I hope there's time that I can speak to that a little bit later as well. Training, so staff needs to be trained. And just back to the risk management compliance program, it must be approved by the board of directors, or person with the highest level of authority, and it must contain prescribed details. Now, going back to what Angela said just now, Angela said, we've got all these crypto asset service provider clients that tell us, don't worry, we are registered and we FICA our clients already. We CDD our clients already. Bear in mind, this RMCP needs to comply with a whole long list of items set out in section 42. And I'm yet to review an RMCP that does comply with all the requirements set out in the legislation. So doing a basic KYC on a person would probably not meet the FICA requirements. So once you've got your RMCP and you've registered with a FIC, you also have to conduct customer due diligence. And let me just correct what I've just said. The requirements don't kick in upon registration. These requirements kicked in the day you became an accountable institution. So you can't avoid these requirements by simply not registering. So you have to conduct customer due diligence. That includes your KYC. You have to conduct record keeping or keep records of your transactions and the CDD conducted, and you must report certain transactions. So as far as your customer due diligence is concerned, it includes customer identification and verification and ongoing due diligence. One of the questions that we were asked in the chat, what is the difference between CDD conducted by our crypto asset service providers and general financial services providers? The difference lies in your risk-based approach tailor-made in your RMCP. So the basic things that we need to establish, such as a person's identity and so on. We have to do across the board. But the way we verify it, checking that Alex Taylor is Alex Taylor, for example, is dependent on the risk posed by Alex Taylor. And if Alex Taylor buys shares, she is likely to be a lower risk client than a person sitting in Syria dealing in crypto assets. So you have to custom make that in your RMCP, and that would be the difference between general or between CDD conducted by various entities. Of course, when you're dealing with a legal person or partnership or trust, red flags, and we've got extra requirements, and that is where the beneficial ownership thing comes in. And I think everybody is very, very hysterical about the beneficial owner requirements, but that of course also stems from our FATF mutual evaluation. I've already mentioned you need to keep prescribed records, and you need to report certain transactions to the FIC, for example, cash transactions, cold hard cash, coins and notes, 49,999 and above. And whatever our crypto assets are, they are certainly not seen as cash or meeting the definition of cash by the FIC. Property of UN sanctioned persons, suspicious transaction or activity reports. So for example, if a person wants to remain anonymous when dealing with you, dealing with requests from FIC, and then international EFTs. Now, I had a question in the chat about the travel rule. This international EFT reporting for transactions of 20,000 Rand and above is only in respect of money being transferred. And again, whatever crypto asset is, maybe going to go to what Angela said. Maybe it's capital, maybe it's not, but it certainly isn't money. So we are not regulating international transfers of cryptos yet under Section 31 of FICA. Just lastly, non-compliance with FICA. If you're a new accountable institution and you decide to ignore what you're supposed to do, the FICA said there is no grace period. But for the first 18 months, they will probably just tell you to take corrective action. So they will not issue financial penalties. But then, of course, they also came out recently, and I have mentioned that, where they issued a notice saying, we are aware of the fact that you guys were supposed to register, you haven't registered, you're on our radar, and please bear in mind, not registering makes you non-compliant, and you could be liable for a fine of 10 million Rand for a human being and up to 50 million Rand for a legal person. And that was a quick overview of the FICA requirements in South Africa. And I'm going to hand back, I think it is to Alex or to Jess.
I'll take it from there. Thanks so much, Era. Yeah, so on the dot, 1 o'clock. Thanks so much to Angela and to Chavi and to Era for a fascinating discussion. It was really awesome listening to you guys and learning more about this. Thanks to everyone who joined us for the session. And if there are any questions in the chat that we haven't had a chance to, sorry, not in the chat, in the Q&A that we haven't had a chance to respond to in this limited time, we'll do our best to get back to you if you've left your name attached to your question. So then, yeah, we all that's left to say is thank you so much from Jessica and I, and we really hope to see you all at the upcoming sessions in the coming weeks. So thanks very much and have a good day further. Goodbye.